Recently, Grade 1 Magistrate Sienna Mugisha ordered Dr. Kizza Besigye to pay 30 million shillings bail on charges of inciting violence, an issue that did not go down well with the opposition activist who went on to challenge the ruling in the High Court, which overturned the decision and recommended a payment of 3 million shillings. Last week, the Law Development Centre Magistrate Court also granted a cash bail of 1 million shillings to members of the FDC Women's League, who were also arrested on the same charges, an issue that was protested by the members of the opposition. Following the two scenarios, Besigye's lawyer Arias Lukwago has today spoken out on the matter, accusing the judiciary of being used by the state, something the judiciary spokesperson Jameson Karemani disputes.
It's largely state influence. The judiciary is under attack, because you heard what General Museveni said. He has issues with the bail. He doesn't believe that bail is a right, especially people charged with political offenses. Offenses like treason, like terrorism, incitement to violence, unlawful assembly, and anything that is got to do with politics. He doesn't want people to, the accused persons to get bail.
Every case that is presented must be granted bail. It's not a must. That's why the Constitution provides that the accused has a right to apply for bail. It means you have a right to apply, and you can apply. You can either be granted or not granted. So when you look at the numbers of those who are granted, they are more than even the few numbers they are talking about. So, yes, there could be an issue which we can look into, but it's not something that they should use as a yardstick for every case.
Fiona Wall-Nabasa, the President Uganda Law Society, says to avoid this, judicial officers must ensure that justice is felt by everyone.
It should not be seen that you are trying to defeat someone's rights or you're treating them like they're already guilty. We need to be sensitive where political cases are concerned, so that it's not seen as political, what do you call that, persecution, using the judiciary as an instrument of political persecution. We do not want to see that.
If we see those kinds of inconsistencies, they are likely to affect the public's trust in the judiciary. And the courts, the most important thing for courts is trust, for the public to go there knowing that I'll get justice.
On so many occasions, court has granted bail to suspects, but in the end, many often choose to jump bail, hence the reason of tightening bail.
In law, you don't visit the crimes of others. A crime committed by another person, you visit it on somebody else. No.
So for me, I think that they should look at all other factors, look at substantial sureties, look at whether this person has the likelihood of interference with investigations, not just look at the monetary term. Because one, even if you set a high monetary term, a person can pay it and jump bail. Still, it wouldn't be justice to the victim.
As practitioners of law, in the courts, we actually depend on even precedents. So if a prosecutor puts a case very strongly forward and has evidence that the last few people who have been dealing with such cases have fled, have jumped bail, then it's a very compelling case for other people not to get bail.
Because of the large numbers of prisoners in detention facilities, some lawyers suggest for denial of bail to be made option. Flavian Nkuze for CTV, PM Edition.
That's right.